Welcome to Legal Talks, Muslim Law Talk 2. In today's session, we'll be looking at conversion to Islam, void and irregular marriages, essentials of a valid marriage, and muta marriage. So, let's get started with today's session. Conversion to Islam. So, we have already discussed a Muslim is a person who submits to the will of God, regardless of their race, nationality, or ethnic background. So, this makes it very clear that the whole world is open to accept Islam. Only condition is he should have a free will to surrender to God. Okay, so conversion can be done in privacy, means it can be a submission to God alone. Okay, so it's not done in a traditional way, so it can be as a sincere effort, or it can also be done in the presence of others. Let's move on. By birth, now if a child is born in Islam, family of an Islam, people who follow Islam, so by birth he will be considered as Muslim, or one can become uh, a Muslim by conversion. He may be, he would have been born and brought up in other religion, but in the later part of his life, he wants to embrace Islam. So when he embraces Islam, he will be again he will become a Muslim. Okay, so basically the condition to become a Muslim is to accept unity of God and prophetic character of Muhammad. These are the two essential conditions which have to be met in order to be a Muslim. So he need to accept unity of God, and he need to believe and follow prophetic character of Prophet Muhammad. And the first step in the process of conversion is Shahada. Okay, and it is one of the most important pillars of the five pillars of Islam, which testify the faith without a delay. Okay, so Shahada is the first step in the process of conversion. In case of, like, for example, if someone is already married and he wants to embrace Islam, in case of a married couple, the party who wishes to embrace Islam should offer Islam to the spouse first. Okay, so this is very important, and if she or he refuses to enter, then the marriage gets dissolved. But however, in the case of a Christian, okay, in the case of a Christian conversion, the marriage is not dissolved. Okay, because there is a close relation between Muslim and Christian community. Okay, and it doesn't get resolved in case of a marriage of Christian. So if a non-Muslim converts to Islam and pronounces talaq, okay, like if a non-Muslim, like if a person who is not from Muslim community, if he is from Hindu community or Christian community, and he enters into Islam and pronounces in the sense he gives talaq against his non-Muslim wife, so such act or such pronouncement will have no effect in law. Okay, so this will not be considered, or this will not be taken into valid grounds. Okay, and we already have discussed in Hindu law polyandry is prohibited, and bigamy is an offense under section 494 of Indian Penal Code. Bigamy is where where if a person enters into a second marriage without a proper termination or without taking permission or convincing the first wife. Okay, so bigamy is multiple marriages at the same time, so which is not permitted by law in the Hindu Marriage Act. Okay, let us look at a case of Skinner and Odie. So in this case, what happened was Skinner and George Skinner were Christian couple. They were married, and in the later part of their life, George Skinner expired. And after his death, after George Skinner's death, Helen cohabited with John Thomas. Helen started to live with another person named John Thomas, and in order to legalize their marriage, so what they did is they converted to Islam. But the court held that it it gave rise to, or they had committed bigamy. Okay, and it was not permissible under the law. Okay, so the law is very strict, and if any act is done with not a pure intention of religion but at selfish ends, that will not be tolerated. Okay, so moving on further, to void and irregular marriages. Basically, we have three types, or the marriages under Muslim law can be studied in three categories. The first category is valid, which is also known as Sahih marriage. Sahih in the sense which is true or which is correct. Okay, so Sahih marriage is a marriage where all the marriage formalities, okay, all the marriage formalities are performed as expected. Okay, so then we have batil marriage. Batil marriage is a void, or a void marriage where the essential marriage conditions are not fulfilled. So batil marriage in short can be said a marriage uh, where it is not complete. Okay, so some formalities of the marriage were still pending. Okay, then we have fasid in the sense irregular. So fasid marriages or irregularities, there are some irregularities like absence of witness. See, in order to solemnize a marriage in Muslim law, the presence of witness is a must in Sunni. Okay, in Sunni system or in Sunni sect, witnesses are compulsory for the solemnization of marriage. Now, if say if a marriage was performed in the absence of witnesses, then such marriage will be termed as irregular. Now, irregular marriages are not voidable marriages. Okay, they are irregularities, and when these irregularities are rectified, okay, the fasid marriage turns into a sahih marriage. Okay, so whenever they overcome, whenever the irregularities are set up, whenever the irregularities are corrected, then it turns into a sahih marriage. Okay, so let us look at some of the irregularities that may possibly arise in Muslim law. Okay, first one is not unlawful. Unlawful in the sense, here, if and the marriage is performed not following on the lawful grounds, okay, then it will be treated as fasid or irregular marriage. A marriage will be termed as irregular or fasid in the absence of witnesses. If there are no witnesses, minimum two witnesses are needed for a regular or sahih marriage. So if witnesses are not there, then the marriage will not be correct. Okay, iddat period in the sense, this is a period that has to be observed by the bride okay, by the bride, or in case of a widow. Okay, so if the husband has died, then there's a certain period of time in which the lady uh, should not enter into the marriage. Okay, so uh, it is a period of like at least two menstrual cycles, or well, at least one menstrual 2 to 3 menstrual cycles. She should not be entering into a marriage. Okay, so it's mainly to ensure that parenthood. Okay, so in that period, if a marriage is performed during the iddat period, then also it will be treated as fasid or irregular marriage. Okay, now in case of guardians, if the marriage is performed with a minor, okay, so there should be a proper uh, authorization given by the guardian. In the absence of the guardian, also the marriage turns fasid. Okay, in Islam, at a time, four marriages are allowed. Now, when all the four wives are alive and the person is trying to enter into a fifth marriage, then it becomes an fasid or irregular marriage. Remember, in Islam, at a time, a person can enter into four marriages with the consent of his wives. Okay, so fifth marriage, in the presence of four wives, if he gets into another marriage or he performs a fifth marriage, then it will be termed as fasid or irregular marriage. Okay, so let's move on further. Essentials of a marriage. What will be the essentials of marriage in Muslim law? So the first one is nikah. Nikah is a marriage contract. Okay, so it is a marriage deed where the two parties who want to solemnize their marriage, they come together to enter into a marriage contract. Okay, so nikah is the technical name for the marriage contract in Muslim law. So civil contract. Basically, in Islam, marriage is considered to be a civil contract. Civil contract in the sense where the two parties agree to share their life and commit to lead a happy life in the form of a contract. So there is a proposee, and proposal is being accepted, and they enter into a contract, marriage contract. So some of legal experts uh, say that marriage in Muslim law is not a sacrament. Sacrament in the sense it is not uh, on, like, it is not purely religious based. It is more of a civil contract type. It's more of a contract than a religious element. But again, there are people like Faizi and Suleiman, okay, who have declared or who have clearly stated that even Muslim law or the marriage in Muslim law is sacred. It is as religious as possible, and it has got an element of sacrament in it. Okay, so we can't purely say that it is just an contract. Okay, so it has got an religious and divine element in it. So moving on further, essentials of a valid marriage. So for marriage to be solemnized in Muslim law, there should be a person to offer, and there should be an acceptance. Like, for example, offer can be made by the bridegroom's father to give his daughter or bride in the marriage, and there should be an acceptance. The family of bridegroom should be ready to accept the bride. So this is the first step. If there should be an offer, and there should be a valid acceptance. Now, sound mind. Okay, the marriage can be solemnized only when the girl is of major age, and she is in a position to understand the things, and she is ready to enter and fulfill the marriage obligations. Okay, a marriage between an insane person uh, cannot be performed. Okay, and it will not be considered as a valid marriage. And free consent in the sense, there should not be any undue pressure, there should not be any undue compulsion. Both the marriage parties should agree with a free will to lead a happy married life. Okay, so there should not be any source of any there should not be any external pressure on the parties to enter into a marriage. Impediments are one of the areas which have to be which are to be taken into consideration before the parties enter into a marriage contract. Okay, so these are the areas which we need to be focused, and we'll discuss this impediments very shortly. What are the different impediments? Uh, the marriage cannot be performed in the prohibited degree. Okay, like a bridegroom cannot marry his sister, a bridegroom cannot marry his aunt. Okay, cannot marry his niece. So there are some impediments, that is conditions for a valid marriage. And the last one is nikah. Basically, a nikah is deed contract which clearly shows the commitment that has been made, the agreement that has been entered between the bride and bridegroom, and it becomes a valid marriage document showing a proof that so and so on so and so date, and in the presence of so and so witnesses has entered into a marriage. Okay, so that is in short, nikah is uh, a written marriage deed which gives a documental proof of the marriage. Now, as we have discussed earlier, what are the different impediments? First one is consanguinity. Consanguinity in the sense, uh, the marriage cannot be performed when within the very close blood relations of the family. Okay, affinity in the sense, a marriage cannot be solemnized in the close relations, like within the brother, within the family, or within the children of the same family, or wherever there is a very close relation between a blood relation between the bride and bridegroom. So in such condition, it comes under prohibited degree, and the marriage cannot be solemnized. And third one is fosterage. Fosterage in the sense, if a child is born and due to some reason uh, the mother could not feed her milk to the child, and she had handed over the child to another lady who had uh, given milk, or she had acted as a mother in saving the life of the child. So in that case, so she becomes an fosterage mother. There cannot be a marriage between a person and a fosterage marriage. If there is any sort of parental relationship between the boy and the lady, so the marriage cannot be solemnized. Okay, so there cannot be a marriage between a male and a foster mother. In simple words, unlawful conjugation in the sense, here we are again talking about closest relation, like a boy cannot get married with his aunt, or a boy cannot a male cannot marry his own sister or cousins. This and all will fall under unlawful conjugation or prohibited degree of marriage. And marriage cannot be solemnized. It will become an fasid marriage if by chance if a marriage is performed in such situations. Let's move on to the muta marriage. Now, basically, this muta marriage is seen and performed more by Shia community. Okay, the word muta itself means enjoyment or use. So, if you look a little bit on historical perspective, why and how this muta marriage came into existence. During the ancient times, people used to travel for business purpose, and they sometimes used to stay uh, 2 or 3 months away from their houses. So this is how this concept of muta marriage came into existence. So what happens in this muta marriage concept is it's a form of temporary marriage. So where a male and female voluntarily agree into an agreement with a fixed amount. Okay, now the duration of the marriage is limited, so they decided beforehand for how many days or months they'll be in the marriage relationship, and the amount will be fixed in the beginning itself. Okay, so this is considered to be uh, as an illegal, uh, not illegal, this is considered to be not a good idea of marriage to enter into, because this is for very limited time frame, and most of scholars consider it as a social evil. Okay, so it is considered or ruled out completely in Sunni law. Sunni law uh, doesn't believe and doesn't permit to enter into a muta marriage, so it doesn't follow muta marriage at all. Okay, now the other exception for this muta marriage is if dower is fixed and time is not limited. Okay, so time is not specified. Okay, then it gets into a permanent marriage, or it takes up the shape of a permanent marriage. Okay, then it is welcomed both by Shia and Sunni community. The major drawback of this marriage is its fixed time frame and the money, which makes it a little risky and brings a little bit of disturbance in the society. Okay, that's the reason mostly this muta marriage is not considered to be a valid marriage in the society. So moving on, let us look at a case of Sayyid Amanullah Hussain versus Rajama. So here, uh, Sayyid Amanullah Hussain married a Harijan female who was embraced who had embraced Islam. Okay, and they were married, and what happened was in 1967, Sayyid Amanullah Hussain died, and after that, the issue of property distribution uh, arised, and it was challenged that Rajamma, wife of Sayyid Amanullah Hussain, will not get her share, or was not uh, the valid property inheritor, as the marriage itself was performed on the grounds of muta marriage. Now, here, though the marriage was performed on the grounds of muta marriage, later it was revealed that there was no term fixed, and the marriage has been solemnized till Sayyid Amanullah Hussain has survived, or till his death point. So this turns the marriage not into an temporary marriage but into the form of an permanent marriage. Okay, in case of permanent marriage, definitely the wife will be the legal heir and she is eligible for husband's property. So in this case, the widow, that is Rajama, was allowed to inherit the property. But again, we have to check all the terms and conditions. So we need to check whether was it a temporary marriage, okay, or was it a permanent marriage. We need to take all the conditions into consideration. Then only we can arrive at a point that the property distribution can be done or not. Okay, so there are all the aspects to be taken into consideration. Now let us look at muta marriage characteristics. Okay, so mutual rights of inheritance, or like here what happens is mutual rights of inheritance or not available to both the parties, but the children that were born uh, or considered to be legitimate, and they can claim the property of both the parties. Okay, then no wives limit. So muta marriage doesn't limit the number of life wives. So it can allow, it can uh, there can be any number of wives in this marriage. Okay, so next, no maintenance, or here there is no maintenance specified in the muta marriage. So it's like uh, a very temporary marriage where the risk factor is more, especially on the bride side. Okay, so if it is stated clearly in the contract that on dissolution of the marriage, so certain amount will be given as maintenance, then it will become unbinding. So then in that case, based on this, he has to fulfill, the husband has to fulfill his promise. Okay, now in case of death of the husband, the iddat period has to be observed. Okay, so there is no minimum dower. So the dower is also fixed, very nominal, because there is no rule that is governing this minimum dower. Okay, no divorce. Okay, so here also it becomes a risky factor, that since it is meant for a temporary contract, so as the time of the contract lapses, the marriage will also automatically dissolve. So there is no possibility, or there is no provision or scope of divorce in case of muta marriage. Okay, now let us say two parties enter into the marriage. Okay, but the marriage was solemnized and there was no consumption. So in this case, the bride can ask for half dower if there was no consumption, and if there was a consumption, if there was a marriage that had taken place between the two parties, and the two parties had solemnized the marriage, and they had entered into marital relationship. So in that case, the lady is eligible to claim the complete dower. Okay, thank you. I hope today's session was good. I am sure definitely you will appreciate my work, and it will be and it will be for sure very helpful to you. Please do like the good work, and please do subscribe my channel, and please do share the good work with the near and dear ones. Okay, have a good day. Take care. Bye.